valid. I don't know how to say in legal terms, but these are frivolous charges, and I will prove beyond reasonable doubt that they are frivolous, and therefore I really cannot stay in court for the charges that I am going to prove, and I cannot stay in prison for the charges that I am going to prove beyond reasonable doubt. And in fact, had the NPA investigated, they would have got the eviction order that says demolish. And had the NPA investigated the extortion, they would have understood that there was an agreement with my tenants that they are going to pay, and in fact they did pay. And I have got the witnesses in respect of them agreeing to pay. So basically, those charges are so frivolous for me. That is number one, my reason for wanting the bail. The other.
Wait, ma'am, just there. I'm happy that we're stretching it, but it's okay. I'm happy with it. You said on the charges of malicious injury to property. You have a court order that so states that you must remove, demolish and remove structures in your property.
That's what it says.
And this property is yours?
This property is ours, yes.
Thank you. On the charges of extortion.
So you're saying the court order was in respect of the removal?
The malicious...
The demolition of the structure?
Yes, demolition and removal of the structure.
Yes.
At this juncture, Your Worship, it is my application to have in a copy of the court order in respect of what my client, Your Worship, is doing.
Any objection?
Thank you.
Any objection?
No objection. And you granted leave to hand in. Thank you.
The court order is admitted evidence and matters.
In addition to the court order that you have, Your Worship, this very same court, I don't mean this one, but the harassment court, we went to the harassment court. This harassment court ruled that the illegal occupiers must pay 70,000 per month. That was the ruling. Now they must pay in the property that they are occupying, because in that property we are paying rates, and then the rates would be loaded with illegal connections, electricity connections and water connections. So when we talked with the community, they understood, because I got them to understand that this is what I am paying for in respect of this farm. That is excluding the amount of the money that we paid to apply for the eviction order. And when few of them who acted with like as if they are all of them, which was not all of them, They went to court, and that case was heard, and the magistrate ruled that they pay 70,000. Now, I am here to see how the other court would say this is extortion, whereas the same court said the people must pay. So I really do not know how the extortion would be proved.
What happened to the harassment case?
The harassment court was dismissed. I think that was in February. The harassment court was dismissed.
With me, Your Worship, I have a copy of what may be the post ruling on the matter in which my client has testified. Thank you, Worship. I crave for leave, Your Worship, to submit same.
Copy of the harassment order is submitted and marked as Exhibit B.
Another an issue about extortion. And I think it is a buzzword now in South Africa. And it has seen the loss of life of people who are alleged to be extortionists, and I believe the same as well. How do you feel about the charges of you being called an extortionist? You are now an extortion.
Of course, this whole matter has got an effect of damaging my good reputation. And to be called an extortionist at this day and age, it also poses a risk on my life where people would believe that I am an extortionist, and I may even be killed because of being labeled as an extortionist.
If I see the perfect picture of what we have tried to bring before this court is that the people who are occupying your place, your land, are the ones now over an agreement that you had with them in a meeting to say that they need to pay rent, are the ones that are calling you an extortionist, or you are now charged for an extortion. Is that what you are telling this court?
Yes.
Now, tell this court, how do you intend to plead on these charges in a court where this matter will be arraigned?
I will definitely plead not guilty.
To one charge or both of them?
To both of them.
And I do want to believe that you have at least tried to show how, without hiding any of your ace cards.
Yes. Yes.
Thank you. Your state of health, how are you?
Of course, due to my age, I am not that well. I have sometimes a short breath, especially in places where the people are smoking. So, and also when I am under pressure, I do have the short breath, And yes, of course, like women issues like isigulo nje sabafazi.
Any experience in the period of your incarceration?
Yes, I did experience the short breath. I did experience some bit of dizziness. Yes.
And how has that affected you right now?
Of course, I am emotionally drained, and health-wise, of course, prison is not a good place to be at, especially for a law-abiding citizen like me.
The requirement is needed on a bail where interest of justice needed to be shown before any court. I will now refer you to the provision of section 64A to E. I will enumerate to you and ask if you will abide or not. Should you then be released out on bail, will you endanger the safety of the public or any particular person, or commit another offense when out on bail?
At the moment, as I said, I am out on bail with Palm Ridge Magistrate's Court, and that bail was awarded last year, and I haven't breached any conditions of that bail. And as I said, I am a law-abiding citizen. If given the bail, I will be here again at the time that I am required to be here.
Will you attempt to evade your trial?
I just want to get you a specific answer. Are you going to endanger the safety of the public or any other person?
No, I will not be able to do so. And in fact, Your Worship, I do not even have capacity to do that.
Thank you. That is satisfied. Will you attempt to evade your trial?
No, definitely not.
If you are then released on bail, will you attempt to influence or intimidate the witnesses in this matter, or conceal or even destroy any evidence?
Sorry to come in. So my the question of whether or not she's going to evade the trial, I'm not sure whether we're still going to mention it, whether or not she's in possession of the passport.
Yes, Your Worship, I was going there.
Right.
Maybe that the court has now given, let me just ask them. Do you have any passport, no?
I have a passport that is kept by NPA.
Already in the hands of the state. If you then released ma'am out on bail, will you attempt to influence or intimidate the witnesses, conceal or destroy any evidence to be used by the state? I know you may not know the evidence.
I will not do that.
Will you undermine or jeopardize the objectives of the justice system or bail conditions?
No, definitely not.
Will you disturb the public peace, order, security, or undermine it?
No.
I heard you said you're unemployed.
Yes.
If bail can be set, the court is inclined to grant bail in this matter, how much can you afford?
2,000 rand.
And who will be paying?
My husband.
I see you look in court. Is he here?
He is here, yes.
Do you think is there anything that I left out which you may wanted me to say, to ask?
No, I think you have covered everything.
Or maybe before that, as per instruction earlier on, I heard you mentioned that there are people who are even ready or who may even come to witness that indeed there was an agreement made amongst the members or the community members in the farm which you said it has been occupied.
Yes, they are also here.
Are they also here?
Yes.
You said that they are ready to testify in your favor.
They are ready to testify to my bail, and they are also ready to confirm that there was an agreement, because that agreement was decided in a meeting, properly constituted meeting.
Your Worship, with this witness, I am. Thank you.
Any cross-examination?
Yes, Your Worship. Status has a few questions. Mrs. Kwinana, you mentioned that you have no assets of value, is that correct?
Yes, I have no assets of value.
And are you familiar with a company called Slipknot Investments 74 Pty Ltd?
Yes.
Are you Slipknot Investments 74 Pty Ltd?
Yes, I am.
Are you affiliated with the company in any way?
I don't know what you mean by affiliation, but that is a family business company. I am the secretary of that company.
Are you a director of the company? Just the same.
I'm not a director, I'm the secretary of the company.
Do you have shares in the company?
No, I don't have shares.
Secondly, you mentioned that you have a pending case of failure to disclose to the PwC your affiliation with them, is that correct?
Yes.
However, the charge which we are aware of is that of fraud. Can you please explain the inconsistency between them?
Yes, in fact, I am happy that you cannot link that failure to disclose and fraud. And that is exactly the reason why we have applied for the objection in court, which will be held in April, because the failure to disclose the previous interest, in which case we tendered with PwC in one other company, and that company, we did not even get that tender, which was the past relationship. That is what they said, and hence we are laying an objection to the charge sheet being fraud, because failure to disclose does not meet the elements of the fraud, especially that I did not benefit, or I did not benefit from their involvement at SAA, and then now it is called fraud. Hence, we have laid an objection, which will be held on the 12th of April.
And you mentioned that on the day you were arrested, which was the 17th of March, where were you on that day?
I was at my house in Blue Valley.
With whom were you there?
I was with my lawyer and my husband.
And you mentioned that the police, you didn't know they were police at the time?
No.
Is that correct? What vehicles were they traveling? Were they marked vehicles, unmarked vehicles?
I cannot confirm the vehicles that they were driving because of the way they did things. However, the security gate can confirm what vehicles they were driving.
Did you see the vehicles at any point in time?
Yes, because I was pushing the vehicle, so I saw the vehicles. But the way I was taken and snatched, I cannot confirm what type of vehicles they are, and I even cannot confirm how many they are, because what are you going to do when you are snatched?
May you please just use one language for the record?
All right.
The reason I ask this question is it's a simple question. Did you see the vehicles?
Yes.
Were there any police brandings on them?
I can't remember. I don't know.
So you couldn't see the SAPS, the big bright letters on the car? You couldn't
No.
at that point in time? Were the police officers, the alleged police officers, were they wearing uniform on the day, or were they dressed in casual clothes?
I don't know, but they were wearing, most of them were wearing navy clothes with brown or navy balaclavas. So that's what I can remember.
And none of them had any police insignia or any indication that they were the police?
I can't remember.
Do you remember the clothing of the one who was attended to you?
The one who said he is Gevan or something, which I later found out in Sentin that he is Javan, I think. Yes, I think he was wearing brown clothes.
Brown clothes. You mentioned that you stay in an estate.
Yes.
Prior to the police having entered, they would have passed the gate, is that correct?
Yes.
What did they tell the people at the gate? Who were they?
I was not there. I was not with them when they got in. So I don't know what did they tell the security.
But prior to them entering the estate, would they not have to be granted permission by the person whom they're going to see?
They did not. They did not ask for the gate code from me.
What I'm asking them is that, do you have security at the gate?
Yes.
So your security never informed you that there were people who are asking to be given access to your compound?
No, they never informed me, but they were there in front of my house, the security police.
So your answer is basically that the police were just given access, you were never informed, they just arrived in front of your house. Is that what you're saying?
I don't know if they were not given access at the gate. I am not the security guard of Blue Valley Golf Estate, so I don't know how did they enter. I cannot say they were not given access or they were given access. I really do not know.
And you mentioned that you sustained bruising during the time when you were being arrested, is that correct?
Yes.
And you also mentioned in the same breath that you resisted being taken away.
Yes, because I did not know that I would be taken away. I knew that I was going to give the statement. I did not know, and I was asking, why am I being taken away? Because the understanding is that I was going to give a statement. So that's why I resisted. That's number one. Number two, those people were so scary. Like if a person is wearing a paraglove, you can't even identify who the person is. And in fact, I really thought that I was being kidnapped.
And let's just go back a little bit. You mentioned that the person who had called from the police, did he introduce himself as a police officer to you?
Le Dimo? Ledimo did not introduce himself as a police, hence that was previous, like when we were arranging if they are going to come. He did not introduce himself as a police. When he first called from the farm, I said to the security guard, let him using his phone, and his phone, my true caller, indicated that it is Sergeant Ledimo. That is how I got to know that it's Sergeant Ledimo. Then I said I can only meet with him if I meet with Fleet Street police station. Any person from police station, but the person that I mentioned is Kowi, because at some stage I went to make a statement with Kowi. Kowi called and said there's a case against you. When can you present yourself to the police station to make a statement? I did go to make a statement. I said to Sergeant Ledimo, I do not know you. Let me, please make an arrangement to see me in the presence of Warrant Officer Kowi, because Warrant Officer Kowi, I went to his office, and therefore I can confirm that he is a policeman.
When did the communication between you and Warrant Officer Kowi take place?
That was maybe, I would say, maybe a week or 2 weeks before the 17th.
Before the 17th. And you mentioned that you made a statement.
No, I did not make a statement.
And on the day when the police entered your compound, was Mr. Mudimo there?
I don't know. There were many of them. And at the time, I did not even know who he is. So I would not say he was there or he was not there, because there were many, maybe about 15 or 16 of them. Maybe one of them was him, or maybe he was not there. I really cannot say he was there or he was not there.
Let us move along now to the reasons for you wanting bail. And you said that your first reason was that the charges aren't valid, as well as the fact that they are frivolous. Is that correct?
Yes.
And you mentioned that you had gotten an eviction order to demolish the properties which are at the Evumbone location in 2020. Is that correct?
Yes.
Did you ever appear in front of the High Court of South Africa here in the East London Circuit Court?
East London?
Circuit Court.
East London Court? Which court?
The East London Circuit Court, the High Court here in East London. Have you ever
appeared many times?
Many times. And are you also aware that there was an interdict which was granted against you to not demolish the houses on your land?
I am aware of that interdict by the Honorable Hart. However, that interdict did not modify the Judge Malusi interdict, the 2020 interdict.
It does.
Then that's...
It does, due to the fact that your application had happened in 2020 and you were subsequently interdicted in 2024, meaning that any procedure or any rights that you're given under a previous order are interdicted in 2020.
Then
did they not explain that to you?
That is a subject of different interpretations. I still maintain that Judge Malusi 2020 order was not nullified by the interim interdict. And another thing, that interim interdict, it is still in process. We are going to court on 21 of July.
Were you legally represented in any of your applications as well as this application by the residents?
No, I don't have money to be legally represented. The reason being that there was in my land where I was paying rates, as I said, where they are using illegal electricity, illegal water, and me paying rates. So I did not have the legal representation.
Was it not explained to you that upon granting this interim interdict, you're not allowed to further demolish any properties on your land?
That is a matter for discussion, and that is a matter for the different interpretations.
I do believe you can answer this question. It's a simple yes or no. Was it explained that you must not proceed with the demolition of the houses?
No, it did not say I must not proceed with the demolition. It did not say.
At this juncture, your worship, the state is giving the defense a chance to affect their interdict.
Can I also have a copy of Hartley's judgment? I just want to read this paragraph that you say. It said I must not continue with demolitions.
This point 2.1, if possible, could you just read it into the record?
I still confirm that this is not saying I must not proceed with demolition. Let me read it for you, Your Worship. The first one is saying, declaring that the removal of the applicants from their home at portion 11 farm 925 by the first, second, and third respondents constitute unlawful eviction. It does not, in this paragraph, there is nothing that says I must stop demolition. And then the second one, directing the first, second, and third respondent forthwith unlock access gates of portion 11 of farm 925 and to allow applicants to return to their homes on the land. There is no stopping of demolition on number 2. Interdicting and restraining first, second, and third respondents from threatening, interfering with, and subjecting the applicants to acts of intimidation and unlawful eviction. There is nothing that says I must stop demolition. The second last one, interdicting and restraining the first, second, and third respondent from advertising and renting the applicant's structures out while the applicants are still occupying them or without the consent of the applicants. The last one, first and second respondents are ordered to pay the cost of this application on the scale as between party and jointly and severally. I mean, really, I cannot see any stopping of demolition in these 4 sentences.
Let us go back to 2.1, where it says, declaring that the removal of the applicants from their homes at portion 11 of form 925 by the first, second, and respondents constitutes unlawful eviction. Would you agree with me, ma'am, that if you were to demolish someone's house, they would have nowhere to stay?
So we are proceeding to pose questions now on this order.
Indulgence, Your Worship, apologies.
I'm not
at this point,
I'm aware that it together with the third order, but it's not before me.
it's good business, Your Worship. In view of the court, Your Worship, and the state submit.
Any objection?
None.
Third court order, the evictions are the amount of exhibit C.
Would you agree with me, ma'am, that if you demolish someone's home, they have nowhere to stay?
Sorry?
If you demolish someone's home, they would have nowhere to stay.
We are here talking about demolition. You said that Judge Hartley's order is saying I must not demolish, and I have proved to you beyond reasonable doubt that the 5 rule misses that are there do not say I must not demolish.
I understand, but can you please answer this one question? Would you agree with me that if you were to demolish someone's home, they would have nowhere to stay?
They will have somewhere to stay because before they stayed there, where were they staying before? And in fact, between 2020 and 2024, they would have got alternative accommodation. So for you to say they would have nowhere to stay is not correct.
So you agree with me that
they would have somewhere to stay.
Your Worship, I still object, Your Worship, to the line of question. This court is not here. It's not sitting here to listen to the interpretation of the orders of the court. What my client has told this court is that this interim order that is before court today has not in any way set aside the decision of the previous, which says my client can demolish and remove the structures that are in the piece of land. This is still, Your Worship, an interim order, and the return date to enforce its finality has not been attended to. Thank you.
Where are you going with that question, Mr. Ndali?
yes, Your Worship, the state is just going to the fact that by demolishing the homes of the residents, it is quite clear that they will have to leave the area and have nowhere to stay, Your Worship, which is in line with 2.1, the removal of the applicants at their homes. Because if you destroy their house, they have nowhere to go. They have to leave.
I would have tried as Section 64 now is concerned. How should you relate that to what will happen?
I will get the issue.
Your Worship, in the my client, Your Worship, wishes to attend to the poor of nature.
How much time does she?
You may ask for
At time now is almost 25 to 12.
25 to 12. Yes, Your Worship. 5 to 10
5 minutes.
5 minutes.
Court is adjourned until. All right,
All right, so there you have it, live visuals there from the East London Magistrates Court. Yakhe Kwinana has taken the stand as she tries to, I suppose, give reasons for why she should be granted bail, and a mouthful has been said, quite frankly. We're taking a 5-minute break, it seems, to allow her to catch her breath and, I suppose, for everybody to reconfigure their bearings. But so far, she's really doubled down on her being the victim in this entire case. You might remember she's being arrested and charged with extortion. She maintains, though, that no extortion has, in fact, been committed. In fact, the exact words she used are, "These are frivolous charges and I will prove it beyond reasonable doubt." She's essentially gone on to explain to the court that as far as she is aware, an interim interdict that was given to the tenants on the property she owns didn't bar her from, in fact, demolishing the structures where these tenants lived. What that interdict did say, and we heard her reading out verbatim, was that these tenants should not be removed from their homes. And I suppose it comes down to interpretation about whether or not, just because there wasn't an explicit mention of the word "do not demolish," if in fact it allowed her to do that, when in fact the interim order itself was clear that the tenants shouldn't be removed. I hope you're keeping up with me. Nonetheless, she's also spoken that she can only afford bail of 2,000 Rand. She's given an assurance to the court that if she were to be granted bail, she will not evade the trial. She's also mentioned the fact that she hasn't been feeling well since her arrest. We heard previously that, in fact, she had collapsed during her detention. She's now told the court that she does suffer from short breath and occasional dizzy spells. She's also mentioned that she's got no capacity to intimidate anyone if she were to be released on bail.